Good morning, everybody. Good morning. Thank you very much for joining us. I thought we'd just we'll give it just a minute just to allow everybody to join, and then we'll kick off. Interestingly, my background does actually look like the weather, which is very unusual. But thank you all for joining us on this, what is actually a beautiful June day. I think probably we'll kick off. I think we've got quite a number of participants. So welcome everybody. Welcome to our business succession webinar. So we were approached about a year ago by AIMS, and it was following a National Craft Butchers survey. And interestingly, that survey showed that over half of local and small abattoirs didn't actually have any succession plan or somebody that was firmly in place that was going to take over the business. And so internally at Roythornes, this got us thinking about owner-managed and family businesses generally across various sectors. And I think we felt, certainly within our corporate commercial and our private client teams, that that actually, particularly with specialist businesses, handing over the business to the next generation can seem pretty daunting. And actually making sure that you've got that next layer of management in place that have got the appropriate skills and background to run the business effectively and efficiently, it clearly is key and can be a challenge in practice. I mean, equally, of course, it may be the case that there isn't actually the next generation of management ready and waiting in the wings. And so there's a timing issue there. I'm sure many of you are familiar with this challenge and probably also have seen the impact on a business where advanced planning or looking ahead to the next generation hasn't really been given sufficient priority in good time. So today we're going to try and help guide you through some of the challenges. And I'm delighted to say I'm joined today by various members of our corporate commercial and private client team. I've got Lizzie Walters from our corporate commercial team, and also Ben Taylor from our private client team here at Roythornes. And we've also got Joe Spencer and Chris Blundell, who are both partners from McIntyre Hudson. And also I'd like to welcome Alice Robinson from G&V Farms, who is also a rural surveyor and senior associate director at Stratton Parker. Alice is very kindly going to give us her insight a little bit later on. So welcome to the panel. Now, the format for the webinar is that the panel will explore various issues relating to business succession planning. And I thought we'd start with the who and end with the how, and also look at some contingency plans in case things do go wrong or there simply isn't an appropriate next generation within the operations or management's team. We're going to talk for about 40 minutes, or the panel's going to talk for about 40 minutes, and then we hope to have some time for questions at the end. I'm sure you're all probably pretty familiar with webinars, but if you would like to contribute to the discussion, we welcome participation. Please do feel free to add your Q&As, your questions and comments in the chat box, and we'll pick up those as we go through. So let's kick off. So I'm going to first look to, I think, Joe and Chris. Now, first things first, let's talk about who. So if I'm wanting to bring in a new employee to assist with the management of my business, how in your view, how can I best attract them to join me, and how equally do I encourage them to stay?
Thank you, Julia, for that lovely introduction, and good morning all. Yeah, the who's a really great question, because a lot of the time it's perhaps not the person you expect it to be. I think as an overview, some of the specialist sectors that we are talking about here and what this webinar is relevant to, perhaps they are in danger of being in a sector which is not as attractive for people as it once was. So the who might not necessarily be the family member you expect it to be. I think any individual you're looking to bring in or looking to step up needs to have two things. You've referred to at the start, Julia, the skills, or at least have the ability to be trained to develop them skills. And culture, I think culture is really important. Family business cultures are usually very different to corporate business cultures. And you might need to identify someone who has got a different culture which you want to bring into the business moving forwards. Attraction, how do we attract them to join the business? There's numerous methods really, and I think businesses are being more creative with this. So they're developing new ways, and I think the main thing I've sort of noted here is that you've got to be competitive. I think that's a key point here, and the competitiveness of your attraction, whatever that looks like, that package will enable the retention of key staff as well. I'll leave it for Chris to sort of provide the details around some items, but there are life and death benefits, there's salary sacrifice schemes. All these items can make an attractive package for the individual from the outset. And it's not getting that individual, okay, we need to work on doing that package at the start and getting that right, but review it, make sure you're reviewing it regularly, frequently, to make sure it's appropriate and it remains competitive in your market space as well. I think the last point really is, the potential for future growth for this person who might be taking on a business. They might be coming in as a future owner, so have a think about that. Explore the options, bring them along for the journey, along the journey with you, so make that conversation transparent. And I think, Chris, if you want to pick up the next bit.
Okay, thanks, Joe. I think as Joe says, culture is important in bringing people in or attracting them to join your organisation and then keeping them. But as always with these things, it always boils down to brass tacks, the green dollar. In the end, it's about reward and remuneration. Joe mentioned things like salary sacrifice. I'll turn to that in a minute. I think for any employee, and you're looking for probably a senior employee here to join your organisation, you're looking to properly structure their reward package. And I tend to look at it in four categories. Obviously, there's the salary piece, and it depends on, as a business, as to what you could afford. And I'll come on to that in a minute. But there's the salary piece, make sure that's competitive. Then there's the annual, what I call the short-term incentive plan, the bonus that you pay every year depending on performance. Make sure that's as the guy or gal would expect, and consider those kind of things. I then move to look at equity incentive, so in other words, shares in the business. Now, it's a complicated area, this one, but it's things that you need to look at. So, for example, it could be a plan, an award of equity after 3 or 5 years, or a crystallization of shares when they meet various KPIs, key performance indicators. Always good to set performance indicators to ensure that they do what you want, as a result of which you reward them. The whole point of bringing a senior person in is to help you grow the business, is to align their interests with yours, essentially. As they help you grow the business, they'll get some reward from it. If they don't, then they don't. So that's like a long-term incentive. And then there's usually a kind of very long-term incentive plan. In other words, shares that they might get on the ultimate sale of the business, if that's what happens. And I know that isn't necessarily what happens, and we'll talk about that in the next question. But essentially, there's always a chance that this business will be sold to a third party, as a result of which then you ensure that they get their reward from that. And in terms of the specifics, I mean, the plans that we tend to look at for share incentives are probably things you've heard about. There's something called the Enterprise Management Incentive Plan. There's something called a Company Share Option Plan. These are essentially options awarded to people, new employees, over shares. So they're not actually shares. You've given nothing away until they've exercised the options, and they are tax favoured. Essentially, this means there's no tax on the award of the option, no tax on the exercise of the option, just capital gains tax when they sell the shares. So those are things that you need to think about and are important, I think, in structuring a package for your new employee to attract him or her into the business. On salary sacrifice, I mean, these are just other benefits you can add around it. So salary sacrifice is rather than paying them salary, which is taxed at up to 47%, and you pay 15% as employers' national insurance, they instead sacrifice some part of that salary for a benefit that's not taxable. That's usually going to be things like pension and things like fuel efficient cars. There are only 4 plans now that give you this tax efficiency. The other ones are cycle to work and childcare. But that's really about it.
Yeah, thank you. That's really informative, Chris and Joe. That's very interesting, and I can sort of imagine. So if I've identified my key person, and I think we're talking, it could be family, it could be somebody that we've brought in from the outside, and you've very helpfully talked about all different types of remuneration and incentives. And one of those you've touched on, Chris, is in relation to actually having a stake in the business, ownership, equity, and that obviously carries with it quite a lot of positives, which is great on both sides, but there can be some risk and challenges. Turning to Ben and Lizzie, what do you think we need to think about if we are looking at actually giving equity interest in the business, so real true ownership of the business?
Yeah, well, thanks, Julia. Well, I'll focus a little bit on the tax parts of that. And the answer to that really depends a little bit on the business structure. But as you've said, that it could be family, it could be someone from outside of the family, it could be someone from outside of the business. So in terms of the business structure, if you're operating as a sole trader, then it might be the case that you're looking to form a partnership or to incorporate. In either case, really, you need to consider the capital gains tax, CGT implications, and the stamp duty land tax implications if there's land that we're talking about as well. In respect of CGT, relief might be available where there's a disposal and a gain. That includes both the partnership scenario and on incorporation. If you're already in partnership, where you're bringing in a partner who will have an interest in capital, then obviously we're talking about capital, CGT needs to be considered. Care needs to be taken in respect of what that partner is going to get, and that's where it comes down to talking in detail about the partnership agreement and how we structure, liaising obviously with the accountant, how we structure their introduction into the business, and it's not dealt with in a sort of haphazard manner. That agreement, as I've said, needs to be properly documented, and not just because of the CGT implications. It has implications, down the line if there's disagreements, for example. If we're dealing with a limited company, then it depends how the introduction is structured. If an existing shareholder sells their interest in the business to an incoming shareholder, then again, that's a capital disposal. That means capital gains tax needs to be considered. If it's an incomer subscribing, then the tax implication should be minimal. So again, a conversation about how is it going to be a disposal of what someone's already got or introduction by way of subscription. Where there is a disposal of an interest in a business, as I said, it might be that CGT relief is available, and I didn't really go into that, but again, it depends on whether it's a gift or a sale, and that might depend on whether it's a family member or a third party, more of a commercial arrangement. You might want to consider holdover relief or business asset disposal relief, which used to be called entrepreneurs relief. The first postpones tax and the second reduces the rate. Although in respect to business asset disposal relief, the lifetime gain limit has reduced significantly in recent years, as I'm sure many people attending today know. In respect of SDLT, so stamp duty land tax, for partnerships, if it's a family member, typically you're covered off. So essentially what we're talking about here is a transfer of an interest in land, or in the case of a partnership, someone coming in into the partnership, perhaps bringing land to the partnership or property. There is a special regime for SDLT and partnerships, which usually covers off family members, though you need to watch for nephews and nieces typically, aunts and uncles obviously the same thing. And if it's unconnected parties, so it's not a family arrangement, then that presents more of an issue for SDLT again. Incorporating a sole tradership, and transferring land or buildings to a connected company, which it typically will be because you'll have the same owners either side, will have SDLT consequences. And again, if it's involving land, that's what you'll need to consider. In each case, how you introduce that person, you'll need to consider what's the right structure for you. And it won't just be the tax that governs that, as I'm sure you know, Julia. There are other drivers to it, but tax can't be forgotten about. The structure will have income tax considerations and other tax administration implication, and one also needs to keep an eye on IHT, because the big thing about inheritance tax is, whilst there might be relief such as APR and BPR, what you don't want to do is set up a structure that's inheritance tax inefficient and have a business that you've worked very hard to create taxed heavily on death. But it's not just a case of saying how much you want to give away and the tax associated with that decision. As I've said, you need to do it right, and I'm sure Lizzie can talk a bit more on that.
Yeah, I think that's really interesting. Thanks, Ben. And I guess just moving away from the tax, just looking more at the governance and operations going forward. I know, Lizzie, you'll have lots to tell us about making sure that we get it right from day one.
Yeah, that's right. So, I mean, for any business, whenever any ownership changes, or if there's any big changes, or I mean, we would say regularly anyway, we want to keep the constitutional documents under review, and we want to make sure that they still work, because it's all very well bringing someone in and getting it all very tax efficient, but then if you've not got the documents to make sure that everyone's working well together and everyone's doing what you think they're doing, the whole thing becomes quite commercially unattractive then when you've brought this person into the business. So I think it's a case of looking at it in the round. So if we're talking about a business that's a company, we'd want to look at articles of association, perhaps a shareholders agreement as well, depending on exactly what people wanted to say. And with a partnership, it's looking at the partnership agreement. And with a lot of the partnerships that we deal with, a lot of partnerships, they're being set up quite informally. It's possibly been a case like what Ben's talked about, where you've been a sole trader, you've decided to bring someone in, and no formal agreements ever really been entered into. And it's, that's quite important then to look at that agreement and make sure it's right, because if you don't, you sort of fall back on very old law from the 1800s, and it's not necessarily what people want at all. So with any of these businesses, where I like to start is, you're giving a bit of this away. What are you letting them do with it in the long term? So if it's shares in a company or a partnership interest, what can that person do with that interest? Can they give it away? So often in family businesses, you find that permitted transfers are included because people think it's appropriate to be able to do that kind of succession and pass the business down the generations. But a founding partner or founding shareholder probably doesn't want an unconnected person involved in their business. They might not want spouses to be included in the business. There can be sort of family dynamics to consider. So we need to sort of talk all of that through. And then in those circumstances, we would also want to include restrictions on transfer, what we call preemption rights, to make sure that if someone is trying to do something with their interest that you don't want them to do, so if they just suddenly decide that they want out, they need to offer it to the other shareholders, they need to offer it back to the other partners first before it goes to a third party, because with all of these sort of owner managed businesses, whether it's family or otherwise, there is quite a key thing in making sure that we know who's coming into the business and where that interest can go. And all of that can be achieved. We can have different rules for family, non-family. It can be as simple or as complicated as people want it to be. It's a case of having that conversation at early doors. The next thing then is, when we've decided where it's going to or what can happen to it, is looking at valuation of that interest, and particularly sort of periods for payment. So if we've brought someone into the business with the idea that they're going to stick around for the long term, they're supposed to be seeing us grow this business, they're our next, they're our succession plan, which is ultimately what we're all here to talk about, is if they suddenly leave and they leave a big hole in the business, that's a real problem. And it's then, well, what are they supposed to be getting? Do we have good leaver, bad leaver provisions? So if they go under a bus, we might want to treat them differently to if they've suddenly got a job for a competitor. So we need to think about all of that, and the commercial implications of that probably depend upon how we've brought the person in the first place. You know, if they've paid for their interest in the first place, and they've paid full value for it, probably you're going to need to give them something on exit rather than just have their cash disappearing, from a commercial point of view. If they've been given their interest, and they've walked away, they may be that they get less when they walk away, because why should they be effectively profiting from that? So again, ultimately we can achieve anything that a business wants to achieve. Whether it's tax efficient or not is a different question, and that that's something that you'd look at in the round. But it's a case of talking about it from the outset. It's too late to look at that when someone's handed in their resignation and you're trying to negotiate it. And then the other big thing is looking at who actually runs the company, who run all the partnership, who's making the decisions, what rights are we giving these people that we're bringing in. It might be that the founding member or members want to retain control, and they're just bringing in these people to sort of dip their toe in the water and see how things get on. It might be that we're happy for everyone to have an equal say, and we need to look at that. It's different in terms of whether it's a partnership or a company, deal with that and how that all works, but it's a conversation to be had. And I suppose it's then down to the business to look at the commercial implications of that. Is a new member going to stick around if you've asked them to put money into this business, but you're not actually giving them any rights in respect of it? We need to consider all of those commercial implications and then get the documents right.
Yeah, thank you. And Joe, just moving on from that, from the individual's perspective, are there tax issues that you think that they would want to take into account in making sure the tax treatment for them works?
Yeah, I think absolutely. There's, I think really well covered by Ben and Lizzie there. That what jumps out from me at me from that is the amount of factors that are involved, and we've got capital gains tax, and one item I wouldn't dismiss is what does it look like afterwards? What has that done to the individual or collection of individuals? So inheritance tax, it's going to be these transactions, they will have impacted your estate. They could have turned a previously protected asset for inheritance tax into cash or something else that is then exposed to inheritance tax. So it's making sure that you're looking at them options and looking at the whole transaction the whole way through, right to the end, and what it looks like after the end there. I would say as well that there are methods there to mitigate the risk, and it's bringing the experts in at the start, as Lizzie alluded to it earlier. Having them conversations early doors to say this is what I want to achieve, to make sure your options are there.
And Chris, I mean, rewarding individuals, from your perspective, have you got some insights just following up on what Joe has said?
Yeah, I think it's important when awarding either shares in a company or allowing someone to acquire shares or a partnership interest, that you're all clear on what reward that is meant to be conveying to the individual. Is it to give them an income stream, dividends if it's shares, partnership income? Is that the reward you want to give them, or is it a capital value on exit? In which case, how are you going to crystallise that capital value? If it's shares, well, either somebody else has to buy the shares from the individual at some point in the future, or the company has to, and it has to have the money to do that. Or are you going to wait until some third party comes to buy the company or the partnership, or is it going to be a flotation? So I think you've always got to be aware that how it's going to be crystallized. People think that with shares, guaranteed slam dunk with shares, I will pay only capital gains tax when I sell them at a 20% rate, or possibly a 10% rate if I qualify for what used to be called entrepreneurs relief. That may not be the case if the company buys the shares back, or it won't be the case if the company buys the shares back, for example. So you just need to be managing that expectation with the individual. But as far as he's concerned or she's concerned, if they're aware of the tax situation, they are being given the same, if you like, benefits as the shareholders by having shares which give them either dividend or capital value on an exit. The owners will get a capital value until we have an exit. So you shouldn't expect that either, perhaps. You just also got to always bear in mind that at the outset, when giving the shares or the partnership interest, no, not the, leaving, I'll do partnership interest in a minute, giving the shares, there's a chance that if they don't pay what's called tax market value for those shares, there's going to be what we call a dry tax charge. In other words, they'll have an income tax bill to pay on the value of the shares they get without any money with which to pay that, because you've just given them a bit of paper, shares. So you've also got to be aware of that. And that's where things like I mentioned in my last answer to the last question, things like tax efficient share incentive plans come in, like EMI options, which allow you to give people an interest in the company, but that doesn't trigger a tax bill. So I think that's the most important thing, I think, there is ensure you know what reward you're giving them, and be aware that the great generous gesture of giving them shares may not be so generous if you've also given them a tax bill without any money with which to pay it.
Yeah, that's very, very useful to understand, Chris. So Lizzie, just coming to you next. You mentioned the dreaded going under a bus, and I think what that made me think of is, okay, so you've got two people that work in business together. What happens if one of those does die? If you've got them working together and one suddenly passes, that presumably can leave a big challenge for the business going forwards. Do you have thoughts on how one can mitigate that, or at least plan for that unfortunate eventuality?
Yeah, and you're right, it can be a massive hole in the business. And I mean, I suppose the one thing that we can't fix is the commercial hole that leaves. And I'm sure that Joe will touch on that later, but is that it's going to depend on how the business is constituted. So I'm going to sound like I'm a stuck record really, but it's getting the documents right from the off. It's too late to do it when the problems arisen. So when we talk about death, there's sort of two issues really, because we need to look at capacity as well, because they do sort of go in hand in hand. And with companies in particular, sort of loss of capacity generally has a bigger issue. So if we take a company that's got two directors, two equal shareholders, one dies, it can be quite easily built into the Articles of Association to say that the sole remaining director has the right to run the company. When we started talking about this webinar, when we wrote this webinar, that really was the case, that it can very easily be built into the Articles of Association. That happened. Unfortunately, the High Court has just decided to reverse the law on that and has made it slightly more difficult. And we do need to be really careful with Articles of Association for sole director companies now, because there are specific provisions that need to be written in. It's not the case that every company that's incorporated under model articles can have sole directors. That at the moment that law has changed, and that's a separate point that we can touch on at another date, I'm sure. But we can do that, and we can then also talk about what happens to the deceased's interest in the company. So does their estate pass to their family? Does it get offered for sale? What happens to that, as I touched on before? If they lose capacity, though, we've got a much bigger problem, because the company's still got two directors. One can't act properly. So we've got a company that is inquorate. It can't function. It can't really make any resolutions at all. And that director can't be sacked. There's Equality Act issues if you try and sack a director as a result of mental capacity, discrimination issues. But also with a 50-50 deadlock company, you've not got the rights to sack them anyway. So what you need is very carefully worded Articles of Association and powers of attorney to deal with that, to make sure that that director's position is still protected, but someone else effectively steps into their place. And that's where the personal documents and the corporate documents all all fit together, and why it's important to be talking to the individuals to make sure that they're doing their own thing and they've got wills and powers of attorney, as well as looking at the corporate documents. With partnerships, the issues are much the same, but we've got a bit more of a blurring of the lines with a partnership, because voting control and ownership sort of go hand in hand. So if we've got a partner who's died or lost capacity, we need to think about who gets their voting rights, because the person who inherits their partnership share technically becomes a partner in the business, depending on how the partnership agreement works. So it's a case of, you know, getting the documents right. And then just going back to what I touched on about surviving shareholders buying out a deceased shareholder and or taking on that interest, is it might not be as simple as that if this has come out of the blue, because they may not have the money to do that. And you're faced with a situation where we need to balance the needs and wants of all the different individuals. Is we need to make sure from the business's perspective that that business interest doesn't end up in the wrong hands, so to speak, but the estate doesn't want to, you know, a deceased, the family of the deceased doesn't want to walk away with nothing when their loved one has put a lot of time and effort into this business. And that's often where we see life insurance policies and trust deeds working with a shareholders agreement to make sure that that all ties together.
Yeah, interesting. And Ben, just touching on what Lizzie's talking about with the life insurance policies and the powers of attorney, from a personal individual's perspective, are you able to share a little bit more information on those as to how they can work in practice?
Yeah, I think we're going to hear a lot today about the importance of ensuring that the personal documents and the corporate documents work well together. And I think everyone will agree that that's a key point. Lizzie's mentioned about life insurance policies, and those policies tend very often to be written into trust, which is important, gives flexibility, and there are estate and business succession planning benefits to that. It's important to check how they're drafted, because the IHC implications of boilerplate trusts tend to be worse than if you have a bespoke trust, which can offer more value both to the individual and to the succession plan as a whole. Just going back to what Lizzie said about the recent changes, I think that's an important point, because it shows the importance of not just putting these documents in place, these arrangements in place, and then forgetting about them, because things change, businesses change, and the regimes change. So, but going back to loss of capacity point, I agree it can cause more issues than death, which sounds a little bit unusual. So lasting powers of attorney in that case are an important tool. They're not particularly unheard of documents nowadays. Lasting powers of attorney, or at least in case of the property and financial affairs lasting power of attorney, used to be known as enduring powers of attorney, and they are a key part of this process. So for partnerships, unless there's a restriction in the LPA itself, you'll need to remember that the individual or individuals appointed are able to influence the business in a very real way. Business LPAs are, as a result, often considered in that case to draw a line effectively between the personal and the business affairs. Indeed, it may be that the partnership agreement is drawn up to allow an attorney to step into the shoes of an incapacitated partner, and it should be considered in that case if the attorney in question is the right person to do that. Do they have the right experience? Do they have the right qualifications? For example, it might be the case that the person running the partnership needs to have certain qualifications in terms of like licenses, for example. And that tends to get forgotten about, that sort of line, particularly in the partnership context. In respect of a company, the attorney can't act in respect of director decisions, but will still be able to act in respect of the donors, the person giving the attorney the power, their shares. That can help to ensure their interests are represented at a board level, but only where that's been considered in the articles, which again highlights the point that needs to be a cooperation between the personal and the corporate. In respect of death, the will needs to be drawn up having considered what's in the articles or the shareholders agreement or the partnership agreement, whatever the case might be. It is frankly useless not considering both, where the testator or testatrix does have a business interest. Ultimately, and as I've said, I think we will all agree that the big takeaway is to make sure that wills, LPAs and the corporate documents all work together to achieve what it is you want to achieve.
Good, yeah, thank you. And Joe and Chris, again, have you got any insights in terms of when we're looking at these products, as clearly it's probably quite a minefield as to how you go about this, and you must have plenty of clients that approach you with these types of questions.
Yeah, absolutely. So we're often talking to the clients about how they can mitigate risk, really, and what products are out there to enable them to do that. And when I'm talking about risk, I'm talking about financial risk, operational risk as well. So there are some different products that can help on either of them and both of them at the same time if the worst does happen in this situation. So I would stress it's important to obtain independent financial advice for these products. So it's a protected activity. Ensure they're drawn up correctly. Ben's mentioned about writing them effectively into trust, and that you understand what you're doing as well. Make sure you're getting that advice from your group of professional advisors, so you know what you're entering into here. I think that's really really important. Key man insurance is a really popular product that we use with a lot of clients. I think it does a couple of things very, very well. So it can provide you with the funds to continue. So something happens to one of your key members of staff, you've got some funds that you can draw down on. But most crucially, I think it provides you with a bit extra time, that will then funds provide you with a bit extra time to make the next decision and look at that as well. So, I think it's a great product to have, or a great product to look at, that's for sure. And then I think just coming onto the tax side of it really a little bit, some of these products you might think are benefit in kind, but if drawn up correctly, they can not bring rise to any tax charges. So it's worth exploring what's out there, and they're an additional attraction and retention tool, which we've talked about earlier. So it can be used in that format as well.
I think from my perspective, Julia, whether it's insight or truism, I don't know which one it is, but I think the question that you've posed of essentially what happens if my business partner suddenly passes away, I think the situation underlines why it's best to sort out succession planning to the next generation or next layer of management well before any of the current owners are at risk of passing away. We don't have a crystal ball, obviously, so that's probably truism, but I think it just underlines the sooner you sort out business succession, what's it going to look like, the better, I guess.
Yes, I think that's, clearly wise words. And I suppose just changing tack slightly, if I'm a founding member of a business, and actually I don't actually want to be bought out if something happens to me, I've got family, I'm very clear that I really want my family to inherit my stake and for the business to continue. Ben, what happens then? How do I ensure that will be the case after I'm gone?
Yeah, I'm about to sound a bit like a broken record here. As I said before, that there's two parts to this, and it depends a little bit on what the will says, which is the natural first port of call, and a little bit about what the corporate documents say. So starting first with the will, increasingly we're seeing flexibility preferred in the form of, say, a discretionary will trust to allow for the right thing to be done on death at that time. So it's quite difficult to predict what will be the right thing to do, particularly if you're leaving to the next generation children, for example, if they're 5 and 6, for example, it might not be the case that how they're going to be when they're 21. You don't know what position they'll be in. So Such trusts don't necessarily have to last that long. It could just be 2 years, for example, to allow what needs to happen, so the right person inherits in the right way at the right time. But discretionary trusts can be used, for example, in that minor scenario, to ensure that people inherit in the right way, and they can actually act as a useful protection. Should the beneficiary that you have in mind to take over the business be experiencing marital or financial difficulties at the time when you unfortunately pass away. It is, generally speaking, a difficult thing to time right. As I've said, it might be the case it's a minor, in which case you might be looking to have someone else act as a caretaker for the business, which presents other issues. It might be the case that a farm manager or the management are the ones carrying on the business in the meantime. But the share or the interest can be held in limbo and used to benefit that person or persons with, say, income from the business, and then ultimately passed on to them when they're seen to be ready. And it can act as a tool to induce them into the business and give them a sense of wanting to be part of that business over time. So anyone being advised on these matters, they should be aware of the trust tax and administration implications. So things like tax returns for the trust. We have got a question on this, and I'll come back to that part at the end. And things like the implications for the business, so the implications on capital allowances, annual investment allowances of a trust being involved in the business. And again, I'll come back to that point because it relates to the question that we've been asked. But as I said, the will is only one part of it, and the governance documents for the business will need to be checked in terms of what's possible, what can be done on death. It needs to work in conjunction with the corporate documentation, and to a certain extent, it depends on what we're talking about. There are cases, quite famous cases, on whether people can leave particular assets to members of the family, where they're held as a partnership asset, for example. So it's worth considering both together.
Yeah, I think that's interesting, because there's always that question mark as well with wills, that people can, in certain circumstances, in most circumstances under a will, you can change your mind. I suppose, coming from the sort of corporate perspective myself, I always think, well, how can you really tie it down? And I suppose, directed more to you, Lizzie, from the corporate document perspective, how can everybody be comfortable that something is set in stone, and that you don't have a situation where a family member could make a will and state one decision, but then actually further down the line change their mind and rewrite their will?
Yeah, you're absolutely right, because as you say, that the will, and you won't necessarily know that it's been written.
No, this is the kind of the this is the, you don't want any surprises after it's too late. So I'd be interested, Lizzie, to hear from you in terms of the corporate documentation, what one can do to avoid that risk.
Yeah, I mean, the thing that you can't avoid is you can't avoid people changing their will. You can't you can't really stop that. But what you can do is quite easily make sure that the corporate documentation, as Ben says, works for how you want it to work. So there can be permitted transfers to allow transfers to the people who you want it to go to. So if the will stays as you've all agreed and you envisage, that all happens, it gets passed down the generations, and that all works as everyone planned. If someone changes their will and tries to do something different, then that's when the preemption provisions that I talked about earlier kick in to say, well, fine, but you're not allowed, you can pass the value down to whoever it is that you've nominated rather than the people who we wanted you to nominate, but you can't actually pass the ownership of the business, and that's where we can then have different payment provisions. So they get paid out over a really long time. The values might be reduced depending on who they've left it to. So we can stop the actual ownership of the business going to people who we don't want it to, and that's the same with companies and with partnerships. I think the other interesting point though is looking at assuming that people do everything that we've agreed, and they do continue to pass the interest on to who we want it to be passed to, which could be on death and it could be in lifetime. So we could do lifetime planning to say that it goes into trusts, which as Ben says, we have had a question on about, what do we think about trusts? And I mean, we use these all the time in passing interest down to the next generation, but keeping it protected by having the trust in place. The big difference with a company and a partnership though is that, as I said before, the decision making and the ownership go hand in hand in a partnership, but less so in a company. So it might be that, going back to your question, Julia, I want my family to inherit my business. I might want them to own it. I might not think any of them are capable of running it. And there might be a difference there. So it might be that we need to look at who are the directors going to be, who are actually going to run it, as opposed to who the shareholders are going to be and who are actually going to own it. And if you've got a partnership, we need to then split the ownership and voting provisions in the partnership, which is not as easy to do.
Yeah, I mean, Joe, Chris, I mean, I can see that. I can see that issue. Have you got some insights from what Lizzie's saying?
Yeah, thanks, Joe. I would probably play devil's advocate a bit and say, is it really right that the family do inherit? And Lizzie pointed out rightly there, there's a difference between sort of running the business and owning the business, absolutely. And is it right that the family does inherit the business? Have they got the right skills? Are they the right people to run it and to own it? Point I mentioned earlier, we're 20, 30 years ago, there probably weren't as many options as there are now for the younger generation in terms of jobs. We're much more service-based country and in terms of that, and perhaps their skills have gone elsewhere and the family have gone elsewhere, and that's where you might consider different structures. I know Roythornes and MHA have done a lot of work around family investment companies and bringing them in where the capital value of the company, or what would be a company, continues to grow in the hands of those you wish it to be. They can set up be set up in quite a bespoke manner, and that might not mean that income could be going elsewhere, but the capital is retained within the family, which might match what we're trying to achieve here, in that we want to keep the business ownership within that family structure.
And invariably situations will arise where one hasn't brought somebody else into the business early, so we end up in a position where I am the sole owner of the business, but I have got to a point where I want to retire. What do I do then? Because I haven't got the luxury of time, but I do want somebody else to take over.
Yeah, retirement is another issue. Look, I think, again, try and have these conversations as early as you can and form an exit strategy. It might be that you're looking for someone to take it on and you can't find that individual. I would say, in terms of retirement, what does that mean? Are we looking to maximize the value of the business for someone else to come along and buy it? We've already covered a bit of that. But you may want to sort of extract as much value as you can. There may be underlying assets that you want to retain that are involved in the business, so consider how you wish to retain them and what structure you would wish to retain them in. I think Lizzie will mention about sort of EOTs and MBOs, but sometimes it comes down to the funding as well. Got an MBO, perhaps you've got to look at how this is going to be funded. Sometimes the high street banks don't want to go near that funding, and so you might need to look at secondary funders or tertiary funders. So there's different options to look at, but it's planning ahead and working through it, agreeing on an exit strategy. I think you want it to be as efficient as possible. both operationally, tax position. So yeah, it's getting the individuals involved. I think I'll leave Ben to comment on the HT impacts of that.
And before we move to Ben, Lizzie, just in terms of Joe mentioned some of the sort of corporate structures. From a corporate finance perspective, what's your experience in terms of the various options available to people in these situations?
Yeah, I mean, the first challenge is finding someone to buy it. You know, and if you can find the person who can buy it at the price you want, you know, other things can be achieved. You know, so management buyout structures where you have, as it sounds, the internal management buying the company, buying the business, probably paying for it over a period of time. It might be that part of the purchase price is paid by loan notes and you don't get all your cash out immediately. Those kind of structures, you know, are becoming more and more popular. Employee ownership trusts are becoming really a lot more popular. You know, we're seeing more of those, and that's you know, sort of passing the ownership to the employees. People are starting to use that as a planning tool as part of their succession planning to hand the business over in you know, in a tax efficient way. You know, and then if you've not got that strong management team, or you've not got the people willing to take it on, or you don't really fancy going down the employee ownership trust route, it's probably then looking, as I say, for an external buyer. You know, venture capitalist companies, depending on the types of business. There are people out there, but it's just a case of finding the people who will pay what you want and in the period that you want it, and sort of whose values align with yours, I suppose. And I suppose then it's looking at what is it that you're going to sell. As I say, how long are you prepared to wait for the cash? That probably impacts on the type of sale that you're going to do. It might be that if you've traded through a company, you're selling the company as a whole, or it might be that you're selling assets from it. 9 times out of 10, shareholders will want to do a share sale because it means that they get out, they get the cash in their own hands, and they sell the entity with all the liabilities in it. But then that's a bargaining position. Who's got the balance of power in that negotiation? Because if you've got a buyer who wants to do an asset sale because they don't want to inherit all of your pre-existing liabilities and they want to cherry pick a bit more, that then means you've got a company to get rid of that's got the cash in, and you need to look at that and take the advice on that. And I think it is ultimately a negotiating exercise and as a bit of a balance of power exercise as to, we've got something that someone else wants and they've got something that we want because they've got the cash, and ultimately coming up with a deal that suits everyone and then documenting that.
Yeah, interesting. And I guess, Chris, taking aside the negotiation and the commercials, there is fairly significant tax treatment issues that both sides have to consider in that type of transaction.
That's right, Julia. There are a number of things to think about in any sale. Capital gains tax is what you're trying to aim for, 10% or 20%. Earn-outs are things which we may need to think about as well. Earn-outs usually are essentially will pay X amount up front, and then depending how well the company performs and how well you hand it on to us, there may be a further payment in 2 or 3 years' time, making sure that's capital gains taxable. But in terms of the thing that's really interesting at the moment, particularly for the people on this call, I think, and their businesses, as Lizzie mentioned, employee ownership trusts, which are very much becoming a popular thing to think about. And why they're popular? They're popular because it effectively allows you to sell your company to a trust for full market value, and effectively not pay capital gains tax on that. It's not as simple as that, but broadly speaking, if you can sell it to the company, to a trust, meet the qualifying conditions for a couple of years after that, you, the sellers, won't have capital gains tax to pay. So even with business asset disposal relief, which gives you a 10% rate, you know, even saving that, if it's on a £1 million business, you know, it's still saving 100,000 by selling it to a trust. And this trust then benefits the employees longer term. You can also when Lizzie mentioned the company having sort of reserves stuck within it, you essentially sell the company to an employee ownership trust over a 4 or 5 year period. So the reserves that are in the company, because that's how it's financed, the company makes contributions to the trust, which then pays out to the selling shareholders. So the reserves can be extracted first off, free of tax, and then profits that are made in the succeeding 4 or 5 years will then be used to pay off the balance of the proceeds, and that also is, as things currently stand, free of tax. So an employee ownership trust is certainly something people need to think about as one of the exit routes. It's not the silver bullet, but it's something that should be on the table. It's no longer, as people initially thought it was, the device for the altruistic business owner who made enough money from the business during their lives and now wanted to pass it on free to the employees, which is the John Lewis model, but it's not just the altruistic gift. It can also be the sale at full market value.
Right, interesting. I think we all like to hear the phrase "free of tax." Yeah, very interesting. I'm just conscious of time, but we have got one final aspect which I thought would be interesting to cover. If I do find a buyer, but actually that buyer doesn't want to buy at all, whether initially or ever, how can we deal with that? Lizzie, this might be one for you to answer.
Yeah, I mean, at its simplest, you might just sell them the bits that they want and keep the rest. As I mentioned, sort of doing an asset sale and then leaving the cash where it is. But that it isn't necessarily going to get the money where you want it to be, but it is the simplest way of doing it. Depending on what it is that they don't want, it might be that you consider a demerger, which is something that we do quite a lot. We often see businesses that have some kind of property element in them that buyer doesn't want, whether it's the land that the business is traded from, or whether it's something completely separate and just happen to be in the same company. And what you can do in those circumstances, subject to usual caveats on tax advice and making sure it works from an accountancy perspective, but you can split it into 2 companies. So buyer can buy the company with what they want in it, and you can keep the bits that they don't want as an investment asset, which can then leave you with quite a good investment to hand down to future generations. So you can kill 2 birds with 1 stone a little bit there. They're really your two options.
Okay, thank you. And before we move, we're going to move on to Alice now. But before we do, Ben, did you have any sort of final comments from a tax perspective, or generally we're just talking about from the demergers? Yeah.
So I think that it's going to sound again tax, but the tax implications of any demerger structure need to be considered before you go down that route, and dealt with carefully. And you also need to factor in time for that process. So the process in terms of preparing a strategy, obtaining the necessary clearances, and so on. And if you are taking on, as Lizzie said, an investment moving forward, don't have the blinkers on the sort of immediate tax implications, but the inheritance tax implications as well. Having a pot of cash instead of what would have been perhaps a trading business, a relievable asset, is going to have IHT implications.
Thank you all of you. It's been really interesting and really valuable insights from all of you. What we thought would be interesting now is I'm going to introduce Alice Robinson, who I said is from G&A Farms and is also a surveyor and director at Strutton Parker. And we've talked a lot about the theory and what we should do and what we would do. And Alice, I think, is going to give us some first-hand insights into perhaps what does happen in reality, and perhaps picking up on some of the points that we've touched on. Alice, over to you.
Thank you, Julie. Good morning, everybody. Yes, as Julie said, I am briefly going to speak about my personal experience with succession planning, or perhaps lack of succession planning, and business continuation. So yeah, I work at Stratton Parker in Stamford, so I am involved with land management and valuations and planning, but also this year I became a partner in the family farm business. And that business is about 700 acres of mainly arable land, farming over near Bedford. Just for a little bit of background for you all, business has been running really since I think the 1970s, under quite an old partnership agreement between my father, his mother, and my great uncle. And although when my father came into the business in his early 20s, so goodness, probably about 40 years ago now, he did try to have some succession conversations with his mother, and particularly with his uncle, and those conversations didn't really go anywhere. What was the older generation perhaps weren't forthcoming in looking to the future and seeing how that business perhaps might be passed down. So ultimately, one of the challenges we had, well, my father had, was there was no succession plan. I suppose the other challenges were we had 3 partners, all aging partners, although they probably wouldn't appreciate me saying that. 2 of them being well into their 90s, and my father being in his 60s. So yeah, we had no succession plan, aging partners, but we also had a farm business that perhaps wasn't profitable, and a structure where we did have a contract farmer basically farming the land with our machinery, but also his machinery, and that wasn't really working for us from a farming family business, but also from, as I say, a profitability point of view. So for the business to be profitable and to look to the future, to continue the farm business, approximately 4 to 5 years ago, I started having some conversations with my father about succession and what were we all going to do. And I suppose that led into reviewing actually what did my father see happening when the other 2 partners died. What did he want to happen? Did he want the farm to continue? Did he want to sell the assets and get out of farming and have an easy life? Who was going to take on the responsibility? And that was really, I suppose, the start of the succession planning and discussions that I was having with my father. I guess in conjunction with that, the catalyst for change was that 2 years ago, my grandmother and my great uncle both passed away within 2 weeks of each other, which I suppose is quite unusual. So a partnership with 3 partners and 2 of the partners, passing away within two weeks of each other, really made us realise that we had to decide what was going to happen and who was actually going to take control and take that business forward. So I suppose that was very much forcing us to make decisions. I probably wouldn't necessarily recommend that. It's always good to, as many of speakers today have said, plan for succession and review that and have that plan in place, rather than maybe being forced to make those decisions in a short space of time. But for us, it meant that we had to sort things out. So I suppose that then led into understanding the wills, and my father had been left the farming assets, and then some of the non-farming assets had been left to both my father and his sister as sort of joint ownership. And that really prompted discussions on actually how we are going to overcome all these issues and challenges with, my father, his sister inheriting, and then the next generation, so my sister, myself, and my cousin. So there's lots of different parties involved, and that's where we all sat down and had conversations in a room. It wasn't just one meeting. There was many meetings and discussions, and probably going round in circles, and sometimes thinking, oh gosh, decisions are never going to be made. And now those conversations were quite honest conversations. We had to understand what assets had been left to who, the shared ownership element, and actually, did my father and his sister want to consider, you know, passing down what they'd been left, or some of what they'd been left, within the 2-year time frame to vary the wills. And that's where we brought in our advisors, so Roythornes and McIntyre Hudson, to help with those conversations. And having everyone in the room at one point was probably the best way of doing that, because it one, hopefully reduces fees, but also you're not having lots of different conversations and everyone's party to what's going on. And those conversations basically led to the fact that, you know, my father wanted to see the business, the family farming business, continue. And it was an opportunity, I suppose, to review the management and the ownership of it, and also practically how it was being farmed. So that's when myself and my husband started to get more involved, and my husband taking on the day-to-day farming operations. So having that opportunity, I mean, he is from a small farming background, but he's ultimately a new entrant, so having the opportunity to take on a farm and actually get involved, you know, doesn't happen very easily. So yeah, very lucky to be able to do that. And that's really, I suppose, the succession plan. It's gone from my father still being involved with the business, but bringing in myself and my husband so that we are taking forward the business and having a lot more involvement in it, while my father takes a bit of a step back, not retiring, but having a step back and knowing that he's got people to take forward that business into the future. So although, you know, that's all kind of resolved itself, and we are now in a new partnership agreement and got lots to learn, but yeah, taking it all forward. There was the challenge that, as I mentioned earlier, I've got a sister, and as part of those conversations, she wasn't at present wasn't interested in becoming part of the farm business or getting involved. She lived elsewhere. She's a teacher. So it's actually having some honest conversations with her, and my father wanting to try and be fair, and her having the opportunities in the future, if she does want to get involved or become a partner, you know, there would be those opportunities, or opportunities to perhaps inherit non-farming assets, to, you know, so she doesn't feel like she's not being considered in the succession planning. So I suppose we've learned quite a lot, and I suppose there's a few items of lessons learned. I know it's been talked about a lot through this presentation, but having the succession conversations early is, I would really recommend. It can be really difficult, but somebody's got to start those conversations. So you need a family member to raise those questions, keep the momentum going, because there's so much to think about, and it's very easy, life gets in the way and people just think, oh, we'll deal with it another time. But yeah, you really need somebody to keep those discussions going. Make sure all parties involved have those discussions, and they are, you know, as open and honest as you can be, and getting your professional advisors in at the relevant time is also quite key as well. So that's quite a quick summary, but hopefully that gives you a bit of an idea of
thank you. That was
experience.
Thank you for sharing that with us. I do think you as a family should be congratulated on managing positively, it sounds. You're smiling, so I assume that all your family is still smiling.
But still got things to sort out. But
yes, but I do think it is tricky, and you clearly have managed a pathway through that successfully, which is not always the case. So I definitely sort of take my hat off to you. And my takeaways from what you've said, I think probably you summed it up brilliantly. I do think it really highlights how sensitive this can all be. We as advisors speak sort of eloquently today with the panel about what one should do. And I think we shouldn't lose sight of that these are relationships, and it can be tricky and sensitive. And actually, as you said, how fantastic that you managed to have such open, transparent and honest conversations. And hopefully, again, what I think you were saying was that the value of the independent advisors that really do play a role in those types of conversations. So thank you, and well done as well. I am conscious of time. We did have some questions. I think looking at the Q&A, I think we've actually successfully answered those as we've been through. So that is great. But perhaps to wrap up, what we could do is I could just ask the panel to perhaps just give us their top tip for our guests, just as a sort of final takeaways before we close. So literally 30 seconds to each of you. Let's start with you, Chris. What's your top tip?
For me, it's kind of building on what was said earlier, and also by Alice there. But essentially, for a successful business succession, you need to be sure you've got a strong senior management team and involve and engage them at an early stage in the growth of the business, either to help you grow the business, i.e. the business owner, for its ultimate sale, or for its passing on to the next generation, or to take it on from you in an MBO, or what's called or a sale to an EOT. I think it's very key to have that senior management if your future generations aren't interested in taking on the business. If they are, they're your succession plan. Alice, for example.
Great, thank you, Chris. And Joe, what would you say is your highlight point?
My top tip, and what I'd always share with clients and people who are looking at this situation, is transparency. Having these conversations, they are really difficult conversations to have, and people do get upset. I've often taken back of tissues into the meeting with me because I know, it's likely that someone's going to get upset, but by being open and transparent, I think you can avoid some of the pitfalls that can come further down the line. There's an expectation that's set out, and it avoids surprises.
Great. And Lizzie, Lizzie and I work in the same team, so I know what Lizzie's going to say, but come on, Lizzie, tell us your top tip.
Get the documents right. Talk to us, get the documents right, and keep them under review. And I'm just going to add a drum that I am beating at the moment of, if you're a sole director company or might end up a sole director at a company, really review them and review them now. This law changes, things change, get them right and keep looking at them. Don't just put them in the drawer.
It's fair to say it's been a pretty monumental change. And if you just want a bit more information, do give Lizzie a call, because there has been some recent law that has changed significantly what you can and can't do if you're sole director companies. And finally, Ben, give us your top tip.
It's always the most difficult going last because everyone's already had all the good ideas. So I'll beat a different drum that's also me. I mean, talking about things that changed recently, the TRS changes for partnerships, for example, they're important. But in terms of the succession point, it's the same sort of thing. It's making sure the documents work well together. Don't do anything in isolation. Take tax advice early, and it'll come as no surprise to anyone on the call, including Alice, that open conversations involving everyone are important.
Great, thank you very much. Well, look, thank you to all of you, Joe, Ben, Lizzie, Chris, and a special thanks to Alice. Thank you very much indeed. And actually, fantastically, we seem to be finishing pretty much bang on time. If you do have any further questions, please do get in touch. You know where to find out the information to get in touch with us, and enjoy the rest of what is proving to be a really beautiful day. Thank you very much for joining us. Bye-bye.